Good afternoon, guys. May 16, 2022, Philippine Standard Time. I'm listening to 888 Sacred Geometry, Attract Infinite Abundance of Love and Money. And also at the same time, I'm listening to The Sound of Inner Peace, 5 Relaxing Music for Meditation, Zen, Yoga, and Stress Relief. I'm reading Administrative Law under Political and International Law, Volume 1 of Verba, Juris, Review Notes by David Robert Aquino. So let's start. General principles. Time and again, the Supreme Court has stressed that those charged with the dispensation of justice, from the presiding judge to the lowest clerk, are circumscribed with a heavy burden of responsibility. Every employee should be an example of integrity, uprightness, and honesty. Administrative agencies. It is a fundamental rule that an administrative agency has only such powers as are expressly granted to it by law, and those that are necessarily implied in the exercise thereof. Powers of administrative agencies. As the constitutional body tasked to enforce and implement election laws, the Commission on Elections has the power to promulgate the necessary rules and regulations to fulfill its mandate. The powers of an administrative body are classified into two fundamental powers: quasi-legislative, quasi-judicial. Quasi-legislative power, otherwise known as the power of subordinate legislation, has been defined as the authority delegated by the lawmaking body to the administrative body to adopt rules and regulations intended to carry out the provisions of law and implement legislative policy. A legislative rule is in the nature of subordinate legislation designed to implement a primary legislation by providing the details thereof. The exercise by the administrative body of its quasi-legislative power through the promulgation of regulations of general application does not, as a rule, require notice and hearing. The only exception being where the legislative itself requires it and mandates that the regulation shall be based on certain facts as determined at an appropriate investigation. Rulemaking power. The powers of an administrative body are classified into two fundamental powers: quasi-legislative and quasi-judicial. Quasi-legislative power, otherwise known as the power of subordinate legislation, has been defined as the authority delegated by the lawmaking body to the administrative body to adopt rules and regulations intended to carry out the provisions of law and implement legislative policy. A legislative rule is in the nature of subordinate legislation designed to implement a primary legislation by providing the details thereof. The exercise by the administrative body of its quasi-legislative power. Quasi-legislative power. Through the promulgation of regulations of general application does not, as a rule, require notice and hearing. The only exception being where the legislature itself requires it and mandates that the regulation shall be based on certain facts as determined at an appropriate investigation. Executive Order Number 1008, which vests upon the construction industry arbitration commission (CIAC) original and exclusive jurisdiction over disputes arising from or connected with contracts entered into by parties involved in construction in the Philippines, clearly provides that the arbitral award shall be binding upon the parties and that it shall be final and appealable except on questions of law, which shall be appealable to the Supreme Court. Disciplinary cases and cases involving personnel actions affecting employees in the civil service, like appointment or separation from the service, are within the exclusive jurisdiction of the Civil Service Commission. The National Power Corporation, or the NAPOCOR, was tasked to carry out the state policy of providing electricity throughout the Philippines, specifically to undertake the development of hydroelectric generation sources, as well as the transmission of electric power to nationwide basis. The Philippine Tourism Authority is a government-owned and controlled corporation which was mandated to administer tourism zones. View that Constitution empowered the Commission on Audit to examine, audit, and settle all accounts pertaining to the revenue and receipts of and expenditures or uses of funds and property owned, held in trust by, or pertaining to the government and its instrumentalities. The National Housing Authority was created pursuant to Presidential Decree number 5757 as a government corporation mandated to implement the government's housing development and resettlement program. To be able to perform this function, the National Housing Authority is vested with sovereign powers. This includes, among others, the exercise of the right of eminent domain, or the right to acquire by purchase privately owned lands and purposes of housing development, resettlement, and related services and facilities. View that the Food and Drug Administration is mandated to examine in every drug, contraceptive, or technology vis-a-vis made for against their inclusion. Mandated. The government agency performs adjudicatory functions when it renders decisions or awards that determine the rights of adversarial parties, which decisions or awards of the same effect as a judgment of the court. Kinds of administrative rules and regulations. As an essential complement, the Commission on Audit has been vested with the exclusive authority to promulgate accounting and auditing rules and regulations, including those for the prevention and disallowance of irregular, unnecessary, excessive, extravagant, or unconscionable expenditures or uses of government funds and properties. The Commission on Elections has the power to liberally interpret or even suspend its rules of procedures in the interest of justice, including obtaining a speedy disposition of all matters pending before it. Requisites for validity. Administrative agencies may exercise quasi-legislative or rule-making powers only if there exists a law which delegates these powers to them. Adjudicatory power. Adjudicatory power. Quasi-judicial or administrative adjudicatory power is the power for administrative agency to adjudicate the rights of or persons before it. A quasi-judicial function is the action, the discretion, etc. of public administrative officers or bodies. Quasi-judicial or administrative adjudicatory power is the power to administrative agency to adjudicate. A quasi-judicial function is the function, discretion, which judicial or administrative adjudicatory. Quasi-judicial function is the action, discretion of public administrative officers or bodies who are required to investigate facts or ascertain the existence of facts, hold hearings and drawing conclusions from them as a basis for their official action and to exercise discretion of a judicial nature. Otherwise stated, an administrative agency performs quasi-judicial functions if it renders awards, determines the rights of opposing parties, or if their decisions have the same effect as the judgment of a court. An agency is said to be exercising judicial function where it has the power to determine what the law is and what the legal rights of the parties are, and then undertakes to determine these questions and adjudicate upon the rights of the parties. An administrative agency performs a quasi-judicial function when it has the power to hear and determine questions of fact to which the legislative policy is to apply and to decide in accordance with the standards laid down by the law itself in enforcing and administering the same law. Its quasi-judicial functions require the agency to investigate facts or ascertain the existence of facts, hold hearings, weigh evidence, and draw conclusions from them as basis for their official action and exercise of discretion in a judicial nature. Otherwise stated, an agency performs a quasi-judicial function when it determines what the law is and adjudicates the rights of the parties before it. Administrative due process. Administrative due process cannot be fully equated with due process in its strict sense, for in the former, a formal trial-type hearing is not always necessary, and technical rules of procedures are not strictly applied. In Antibay v. CIR, the court laid down the cardinal rights of parties in administrative proceedings as follows. First, the right to a hearing, which includes the right to present one's case and submit evidence in support thereof. The tribunal must consider the evidence presented. The decision must have something to support itself. The evidence must be substantial. And fifth, the decision must be rendered on the evidence presented at the hearing, or at least contained in the record and disclosed to the parties affected. Also, and sixth, the tribunal or body or any of its judges must act on its or his own independent consideration of the law and the facts of the controversy, and not simply accept the views of a subordinate or arriving at a decision. Seventh, the board or body should, in all controversial questions, render its decision in such a manner that the parties to the proceeding can know the various issues involved and the reason for the decision rendered. Administrative appeal and review. Jurisdiction is defined as the power and authority of a court to hear, try, and decide a case. Jurisdiction over the subject matter is conferred only by the Constitution of the law. Primary jurisdiction is the power and authority vested by the Constitution or by statute upon an administrative body to act upon a matter by virtue of its specific competence. Administrative res judicata. Res judicata. Res judicata. Res judicata is a concept applied in the review of lower courts' decisions. Sumakto ka rin. In accordance with the hierarchy of courts. Court decisions. In accordance with the hierarchy of courts. But jurisprudence has also recognized the rule of administrative res judicata, the rule which forbids the reopening of a matter once judicially determined by competent authority applies as well to the judicial and quasi-judicial facts of public executive or administrative officers and boards acting within their jurisdiction as to the judgments of courts having general judicial powers. It has been declared that whenever final adjudication of persons invested with power to decide on the property and rights of the citizen is examinable by the Supreme Court upon a writ of error or a certiorari, such final adjudication may be pleaded as res judicata. Final adjudication may be pleaded as res judicata. To be sure, early jurisprudence was already mindful that the doctrine of res judicata cannot be said to apply exclusively to decisions rendered by what are usually understood as courts without unreasonably circumscribing the scope thereof, and that the more equitable attitude is to allow extension of the defense to decisions of bodies upon whom judicial powers have been conferred. In Ligtas versus People, this court reiterated that res judicata may also be applied to decisions rendered by agencies in judicial or quasi-judicial proceedings and not to purely administrative proceedings. In Salazar versus De Leon, this court further held res judicata is a concept applied in the review of lower court decisions in accordance with the hierarchy of courts, but jurisprudence has also recognized the rule of administrative res judicata, the rule which forbids the reopening of a matter once judicially determined by competent court applies as well to the judicial and quasi-judicial facts of public, executive, administrative officers and boards acting within their jurisdiction as to the judgments of courts having general judicial powers. It has been declared that whenever final adjudication of persons invested with power to decide on the property and rights of the citizen is examinable by the Supreme Court upon a writ of error or a certiorari, such final adjudication may be pleaded as res judicata. To be sure, early jurisprudence was already mindful that the doctrine of res judicata cannot be said to apply exclusively to decisions rendered by what are usually understood as courts without unreasonably circumscribing the scope thereof, and that the more equitable attitude is to allow extension of the defense to decisions of bodies upon whom judicial powers have been conferred. Fact-finding, investigative, licensing, and rate-fixing powers. In administrative cases, substantial evidence is required to support any findings. The weight of evidence required in administrative investigations is substantial evidence, or that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. Judicial review. Judicial review. This court's power judicial review is conferred on the judicial branch of the government in Section 1, Article 8 of our present 1987 Constitution. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Judicial power includes the duty of the courts to justice, to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of government. Such power of judicial review was early and exhaustively expounded upon by Justice P. Laurel, Justice Jose P. Laurel, in the definitive 1936 case of Angara versus Electoral Commission. After the effectivity of the 1955 Constitution, whose provisions, unlike the present Constitution, did not contain the present provisions in Article 8, Section 1, Paragraph 2 on what judicial power includes. Thus, Justice Laurel discoursed, in times of social disquietude or political incitement, the great landmarks of the Constitution are apt to be forgotten or marred, if not entirely obliterated. In cases of conflict, the Judicial Department is the only constitutional organ which can be called upon to determine the proper allocation of powers between the several departments and among the integral or constituent units thereof. Doctrine of primary administration of jurisdiction. The doctrine of primary jurisdiction does not allow a court to arrogate unto itself authority to resolve a controversy, the jurisdiction over which is initially lodged with an administrative body of special competence. To assume the power is to short-circuit the administrative process. Doctrine of exhaustion of administrative remedies. Doctrine of primary administration jurisdiction. The doctrine of primary jurisdiction does not allow a court to arrogate unto itself authority to resolve. Doctrine of exhaustion and controversy, the jurisdiction over which it is initially lodged with an administrative body with special competence. To assume the power is to short-circuit the administrative process. Doctrine of exhaustion of administrative remedies, where the enabling statute indicates a procedure for administrative review and provides a system of administrative appeal or reconsideration. The Supreme Court exercised its power of judicial review in cases otherwise rendered moot and academic by supervening events on the basis of certain recognized exceptions. The doctrine of exhaustion of administrative remedies requires that, for reasons of law, comity, and convenience, where the enabling statute indicates a procedure for administrative review and provides a system of administrative appeal or reconsideration, the courts will not entertain a case unless the available administrative remedies have been resorted to and the appropriate authorities. Doctrine of finality of administrative action. In this regard, we quote this well-settled doctrine to wit: findings of administrative agencies which have acquired expertise because their jurisdiction is confined to specific matters are generally accorded not only respect but even finality. Judicial review by this court does not go so far as to evaluate the sufficiency of the evidence upon which the deputy minister and regional director base their determinations, but are limited to issues of jurisdiction or grave abuse of discretion. It is well established in our jurisprudence that the decisions and orders of administrative agencies rendered pursuant to their quasi-judicial authority have upon their finality the force and binding effect of a final judgment within the purview of the doctrine of res judicata. Election law. Suffrage. The court's definition of civil rights was made in light of their distinction from political rights, which refer to the right to participate directly or indirectly in the establishment or administration of government, the right of suffrage, the right to hold public office, the right of petition, and in general, the rights pertinent to citizenship, vis-a-vis the management of government. Although Go versus Byron involved the conduct of recall elections, the 1.4 billion appropriation under the FY 2014 under the fiscal year 2014 GA was for the conduct and supervision of elections, referenda, recall votes, and plebiscites. The term election is comprehensive enough to include other kinds of electoral exercises, including initiative elections. As earlier mentioned, the COMELEC's constitutional mandate is to enforce and administer all laws relative to the conduct of an election, plebiscite, initiative, referendum, and recall. The Constitution further states that the funds certified by the COMELEC as necessary to defray the expenses for holding regular and special elections, plebiscites, initiatives, referenda, and recalls shall be provided in the regular or special appropriations, and once approved shall be released automatically. Thus, the budgetary allocation for the regulation of elections, identified as the COMELEC's MFO1, should necessarily also cover expenses for the conduct of initiative elections. The people's sacred right of suffrage, the citizenry's vital weapon in effecting a peaceful change of government and in achieving and promoting political stability. Qualification and disqualification of voters. To constitute a disqualification to run for an elective local office, the following requisites must concur. First, that the official concerned has been elected for 3 consecutive terms and in the same time in the same local government post. That he has, number 2, that he has fully served 3 consecutive terms. Registration and deactivation of voters. The consequence of non-compliance is deactivation, which refers to the removal of the registration record of the registered voter from the corresponding precinct book of voters for failure to comply with the validation process as required by RA 10367. Section 7 states, Section 7, deactivation. Voters who fail to submit for validation on or before the last day of filing of application for registration for purposes of the May 2016 elections shall be deactivated pursuant to this Act. Notably, the penalty of deactivation as well as the requirement of validation neutrally applies to all voters. Thus, petitioner's argument that the law creates artificial class of voters is more imagined than real. There is no favor accorded to an obedient group. If nothing, non-compliance with the disobedient only rightfully results into prescribed consequences. Surely this is beyond the intended mantle of the equal protection of the laws, which only works against undue favor and individual or class privilege, as well as hostile discrimination or the oppression of inequality. Inclusion and exclusion proceedings. Another provision which did not in self-destruct is that which provides that any city or municipal judge who includes or excludes any voter without any legal basis in inclusion and exclusion proceedings shall be guilty of an election offense. Although this provision is found in Section 10 of Executive Order Number 134 supposedly with limited application as the Enabling Act for the elections for members of Congress on May 11, 1987 and for no other purposes. Clearly, the intent of the law was to give certiorari jurisdiction to the Commission on Elections because the Pimentel case said there was none to fill a void in the law and avoid an incongruous situation. The municipal and metropolitan trial courts shall have original and exclusive jurisdiction over all cases of inclusion and exclusion of voters in their respective cities or municipalities. Decisions of the municipal or metropolitan trial courts may be appealed by the aggrieved party to the regional trial court within 5 days from receipt of notice thereof. Otherwise, said decision shall become final and executory. The regional trial court shall decide the appeal within 10 days from the time it is received, and the decision shall immediately become final and executory. No motion for reconsideration shall be entertained. Local and overseas absentee voting. Considering the unison intent of the Constitution and RA 9189 and the expansion of the scope of that law with the passage of RA 9225, the irresistible conclusion is that duals may now exercise the right of suffrage to the absentee voting scheme and or overseas absentee voters. Duals, pwede na. May now exercise right of suffrage to the absentee voting. Overseas absentee voters. Irresistible conclusion is that duals RA 9225, RA 9189, RA 9225. Absentee voting, detainee voting, absentee voting, overseas absentee voters. RA 9189 defines the terms adverted to in the following wise. Absentee voting refers to the process by which qualified citizens of the Philippines abroad exercise their right to vote. Overseas absentee voter refers to a citizen of the Philippines who is qualified to register and vote under this act but otherwise is qualified by law who is abroad on the day of elections. The process by which qualified citizens of the Philippines abroad exercise their right to vote. Absentee voting, overseas absentee voters. Voter refers to a citizen, refers to the process in the Philippines by which qualified citizens of the Philippines abroad exercise their right to vote. Absentee voting. Overseas absentee voter is referred to as citizen of the Philippines who is qualified to register and vote under this act, not otherwise disqualified by law, who is abroad on the day of elections. Detainee voting. Detainee voting refers to people who will vote and are confined in jail, formally charged for any crime or crimes and awaiting undergoing trial or serving a sentence of imprisonment for less than 1 year, whose conviction of a crime involving disloyalty to the duly constituted government, such as rebellion, sedition, violation of the firearms law, or any crime against national security, or for any other crime, is on appeal. Political parties. Jurisdiction of the Commission on Elections over political parties. The jurisdiction of the COMELEC over a petition to deny due course to or cancel certificates of candidacy continues even after election if for any reason no final judgment of disqualification is rendered before the election. The candidate facing disqualification is voted for and receives the highest number of votes, and provided further that the winning candidate has not been proclaimed or has taken his oath of office. Registration of political parties. Any organized group of persons seeking registration as a national or regional political party may file with the Commission a verified petition attaching thereto its constitution and bylaws, platform or program of government, and such other relevant information as may be required in the Commission. The Commission shall, after due notice and hearing, resolve the petition within 10 days from the date it is submitted for decision. Candidacy. Qualifications and disqualifications of candidates. To constitute a disqualification to run for elective local office, the following requisites must concur. First, that the official concerned has been elected for 3 consecutive terms in the same local government post. That he has fully served 3 consecutive terms. A COC, cancellation proceeding, essentially partakes of the nature of a disqualification case. The cancellation of a COC essentially renders the votes cast for the candidate whose certificate of candidacy has been cancelled as stray votes. If the disqualification or COC cancellation or denial case is not resolved before the election day, the proceeding shall continue even after the election and the proclamation of the winner. Meanwhile, the candidate may be voted for and even be proclaimed as the winner, but the COMELEC has jurisdiction to deny due course and cancel his or her COC continues. This rule likewise applies even if the candidate facing disqualification has already taken his oath of office. The only exception to this rule is in the case of congressional and senatorial candidates, where the COMELEC ipso jure loses jurisdiction in favor of either the Senate or the House of Representatives Electoral Tribunal after the candidates have been proclaimed, taken the proper oath, and also assumed office. Filing of certificates of candidacy. Section 74 requires the candidate to state under oath in his COC that he is eligible for said office. A candidate is eligible if he has a right to run for the public office. If a candidate is not actually eligible because he is not a registered voter in the municipality where he intends to be elected, but still he states under oath in his certificate of candidacy that he is eligible to run for public office, then the candidate clearly makes a false material representation of a group to support a petition under Section 78. It is interesting to note that Hayudini was in fact initially excluded by the ERB as a voter. On November 30, 2022, the ERB issued a certificate confirming this approval of Hayudini's petition for registration. This is precisely the reason why he needed to file a petition for inclusion in the permanent list of voters in Barangay Bintaulan before the MCTC. Thus, when he stated in the COC that he is eligible and for said office, Hayudini made a clear and material misrepresentation as to his eligibility because he was not in fact registered as a voter in Barangay Bintaulan. Effect of filing. The certificate of candidacy shall be under oath and shall state that the person filing it is announcing his candidacy for the office and constituency stated therein, that he is eligible for said office, his age, sex, civil status, place and date of birth, his citizenship, whether natural born or naturalized, the registered political party to which he belongs, if married, the full name of the spouse, his legal residence, giving the exact address, the precinct number, barangay, city or municipality and province where he is registered voter, his post office address for election purposes, his profession or occupation or employment, that he is not a permanent resident or an immigrant from a foreign country, that he will support and defend the Constitution of the Republic of the Philippines and will maintain true faith and allegiance thereto, that he will obey the laws, legal orders, decrees, resolution, rules and regulations promulgated and issued by the duly constituted authorities, that he assumes the foregoing obligations voluntarily without mental reservation or purpose of evasion, and that the facts stated in the certificate are true and correct to the best of his own knowledge. From the point of view of the common citizen who wants to run for a local elective office, the above recital contains all the requirements that he must satisfy. It contains the basic and essential requirements applicable to all citizens to qualify for candidacy for a local elective office. These are the formal terms of entry to local politics. The citizen must not only possess all these requirements, he must positively represent in his COC that he possesses them. Any falsity of the requirements constitute a material misrepresentation that can lead to the cancellation of the COC. In case of valid substitutions, after the official ballots have been printed, the votes cast for the substituted candidates shall be considered as stray votes, but shall not invalidate the whole ballot. For this purpose, the official ballots shall provide spaces where the voters may write the name of the substitute candidates if they are voting for the latter, provided however that if the substitute candidate of the same family name, this provision shall not apply. Nuisance candidates. A nuisance candidate is defined as one who, based on the attendant circumstances, has no bona fide intention to run for the office for which the certificate of candidacy has been filed, his sole purpose being the reduction of the votes of a strong candidate upon the expectation that ballots with only the surname of such candidate will be considered stray and not counted for either of them. Proceedings in cases nuisance candidates require prompt disposition. The law mandates the Commission and the courts to give priority to cases of disqualification to the end that the final decision shall be rendered not later than 7 days before the election in which the disqualification is sought. In the more recent case of Martinez III versus House of Representatives Electoral Tribunal, this court likewise applied the rule in COMELEC Resolution number 4116 not to consider the votes cast for a nuisance candidate stray but to count them in favor of the bona fide candidate, notwithstanding that the decision to declare him as such was issued only after the elections. As illustrated in Bautista, the pendency of proceedings against a nuisance candidate on election day inevitably exposes the bona fide candidate to the confusion over the similarity of names that affects the voter's will and frustrates the same. It may be that the factual scenario in Bautista is not exactly the same as in this case, mainly because the COMELEC resolution declaring Edmund Bautista a nuisance candidate was issued before and not after the elections, with the electorate having been informed thereof through newspaper releases and other forms of notification on the day of election. Undeniably, however, the adverse effect of the voters' will was similarly present in this case, if not worse, considering the substantial number of ballots with only Martinez or C. Martinez written on the line for representative, over 5,000, which have been declared as stray votes, the invalidated ballots being more than sufficient to overcome private respondents' lead of only 453 votes after their recount. Effect of disqualification. The fact that the candidate who obtained the highest number of votes is later declared to be disqualified or not eligible for the office to which he was elected does not necessarily entitle the candidate who obtained the second highest number of votes to be declared the winner of the elective office. The votes cast for a dead, disqualified or non-eligible person may not be valid to vote the winner into the office or maintain him there. However, in the absence of a statute which clearly asserts a contrary political and legislative policy on the matter, if the votes were cast in the sincere belief that the candidate was alive, qualified, or eligible, they should not be treated as stray, void, or meaningless. This is particularly true whereas in this case there is only one other candidate who ran for the public office, or votes for the deceased or not non-qualified candidate are still expressive of a public clamor that the majority of the voters do not like the losing candidate to be their representative or to hold the reins of government for them. To constitute a disqualification to run for an elective local office, the following requisites must concur: that the official concerned has been elected for 3 consecutive terms in the same local government post and that he has fully served 3 consecutive terms. Campaign. The Solicitor General rightly points out that the same provision does not prohibit billboards as lawful election propaganda, only regulates their use to prevent premature campaigning and to equalize, as much as practicable, the situation of all candidates by preventing popular and rich candidates from gaining undue advantage in exposure and publicity on account of their resources and popularity. Moreover, by regulating the use of such election propaganda materials, the Comelec is merely doing its duty under the law, under Sections 3 and 13 of the Fair Elections Act. All election propaganda are subject to the provision and regulation by the Comelec. Premature campaigning. A recent example of a flagrant violation of the election laws is the premature campaigning. Section 18 of the Omnibus Election. Section 18 of the Omnibus Election Code provides that it shall be unlawful for any person, whether or not a voter or candidate, or for any party or association of persons to engage in an election campaign or partisan political activity except during campaign period. That political party may hold political conventions or meetings to nominate their official candidates within 30 days before the commencement of the campaign period and 45 days for presidential and vice presidential election. The Solicitor General rightly points out that the said provision does not prohibit billboards as lawful election propaganda. It only regulates their use to prevent premature campaigning and to equalize as much as practicable the situation of all candidates by preventing popular and rich candidates from gaining undue advantage in exposure and publicity on account of their resources and popularity. Moreover, by regulating the use of such election propaganda materials, the Comelec is merely doing its duty under the law, under Sections 3 and 13 of the Fair Elections Act. All election propaganda are subject to the provision and regulation by the Comelec. Prohibited contributions. Admittedly, contributions and expenditures are made for the purpose of influencing the results of the elections. Lawful and prohibited election propaganda. Election propaganda, whether on television, cable television, radio, newspapers, or any other medium is hereby allowed for all registered political parties, national, regional, sectoral parties, or organizations participating under the party list elections, and for all bona fide candidates seeking national and local elective positions subject to the limitation on authorized expenses of candidates and political parties, observance of truth in advertising, and to the supervision and regulation by the Commission on Elections, COMELEC. Election propaganda, whether on television, cable, television, radio, newspapers, or other medium, is hereby allowed. Ito lang. purpose of this act, this act, lawful election propaganda. Lawful election propaganda shall include 30.1 pamphlets, leaflets, cards, decals, stickers, or other written or printed materials the size of which does not exceed 8 1/2 inches in width and 14 inches in length. 3.2 handwritten or printed letters urging voters to vote for or against any particular political party or candidate for public office. 3.3 cloth, paper, or cardboard posters, whether framed or posted, with an area not exceeding 2 feet by 3 feet, except that at the site and on the occasion of a public meeting or rally or in announcing the holding of said meeting or rally, streamers not exceeding 3 feet by 8 feet in size shall be allowed, provided that said streamers may be displayed 5 days before the date of the meeting or rally and shall be removed within 24 hours after said meeting or rally. Paid advertisements in print or broadcast media, provided that the advertisements shall follow the requirements set forth in Section 4 of this Act, and all other forms of election propaganda not prohibited by the Omnibus Election Code or this Act. Limitations on expenses. To carry out the objectives of the preceding sections, no candidate or treasurer of a political party shall directly or indirectly make any expenditure except for the following purposes: A. For traveling expenses of the candidates and campaign personnel in the course of the campaign, and for personal expenses incident thereto, for compensation of campaigners, clerks, stenographers, messengers, and other persons actually employed in the campaign, for telegraph and telephone tolls, postage, freight, and express delivery charges, for stationery, printing, and distribution of printed matters relative to candidacy, for employment of watchers of the polls, for rent, maintenance, and furnishing of campaign headquarters, office, or place of meetings, for political meetings and rallies, and the use of sound systems, lights, and decorations during said meetings and rallies, for newspaper, radio, television, and other public advertisements, for employment of counsel, the cost of which shall not be taken into account in determining the amount of expenses which a candidate or political party may have incurred under Section 100 and 101 thereof, for copying and classifying lists of voters, investigating and challenging the right to vote of persons registered in the list, the costs of which shall not be taken into account in determining the amount of expenses which a candidate or political party may have incurred under Sections 100 and 101 thereof, or for printing sample ballots in such color, size, and maximum number as may be authorized by the Commission, and the cost of such printing shall not be taken into account in determining the amount of expenses which a candidate or political party may have incurred under Sections 100 and 101 thereof. Statement of contributions and expenses. Every candidate and treasurer of the political party shall, within 30 days after the day of the election, file in duplicate with the offices of the Commission the full, true, and itemized statement of all contributions and expenditures in connection with the election. No person elected to any public office shall enter into upon the duties of his office until he has filed the statement of contributions and expenditures herein required. The same prohibition shall apply if the political party which nominated the winning candidate fails to file the statement required herein within the period prescribed by this Act, except candidates for elective barangay office. Failure to file the statements or reports in connection with electoral contributions and expenditures as required herein shall constitute an administrative office for which the offender shall be liable to pay an administrative fine ranging from 1,000 pesos to 30,000 pesos in the discretion of the Commission. The fine shall be paid within 30 days from receipt of notice of such failure, otherwise it shall be enforceable by a writ of execution issued by the Commission against the properties of the offender. It shall be the duty of every city or municipal election registrar to advise in writing By personal delivery or registered mail within 5 days from the date of election, all candidates residing in its jurisdiction to comply with their obligation to file their statements of contributions and expenditures. For the commission of a second or subsequent offense under this section, the administrative fine shall be from 2,000 pesos to 60,000 pesos. In the discretion of the commission, in addition, the offender shall be subject to perpetual disqualification to hold public office. Board of Election Inspectors and Board of Canvassers. Let's have a break. Board of Election Inspectors and Board of Canvassers. Each Board of Election Inspectors shall be composed of a chairperson, poll clerk, and third member. Powers. The Board of Canvassers is a ministerial body. It is enjoined by law to canvass all votes on election returns submitted to it in due form. It has been said improperly that its powers are limited generally to the technical or mathematical function of ascertaining and declaring the apparent result of the election by adding or compiling the votes cast for each candidate as shown on the face of the returns before them, and then declaring or certifying the result so ascertained. The simple purpose and duty of the canvassing board is to ascertain and declare the apparent result of the voting, while all other questions are to be tried before the court or other tribunal for contesting elections or in Quo Warranto proceedings. Remedies: petition to deny due course or or cancel certificate of candidacy. In the exercise of the said jurisdiction, it is within the competence of the COMELEC to determine whether false representation as to materials facts was made in the certificate of candidacy that will include among others the residence of the candidate. COMELEC has the jurisdiction to deny due course to or cancel a certificate of candidacy. Petition for disqualification. The time to file petition for disqualification should be filed the day before the election. This deadline is mandatory. A petition to disqualify a candidate as would validly cancel any votes cast for him as stray votes, if granted, should be filed before the day of elections. This will enable a substitute candidacy to be filed, thus giving the electorate a choice of alternative candidates. Issue of candidates disqualification. So this book, marami siyang errors. Like kanina, may errors siya. Dalawang beses na print yung isang buong paragraph about lawful and prohibited election propaganda. So ngayon naman, may mga hindi mo from grammar siyang na-print. So, we corrected it. Issue of candidates disqualification best resolved in the election protest after a proclamation had been made and an election protest had been launched. Failure of election. Call for special election. Special elections are those held to fill a vacant elective position where the rule of succession does not apply, or those held after a failure of regular elections wherein the results from concerned precincts can still affect the final results of the concerned elective position in question for a barangay or district or city, municipality or province. Pre-proclamation controversy. Pre-proclamation controversy is defined in section 241 of the Omnibus Election Code as referring to any question. Failure of election. Call for special election. Special elections are those held to fill a vacant elective position where the rule of succession does not apply, or those held after a failure of regular elections wherein the results from concerned precincts can still affect the final results of the concerned elective position in question for barangay or district or city, municipality or province. Pre-proclamation controversy. Pre-proclamation controversy is defined in section 241 of the Omnibus Election Code as referring to any question pertaining to or affecting the proceedings of the Board of Canvassers which may be raised by any candidate or by any registered political party or coalition of parties before the board or directly with the commission, or any matter raised under section 233, 234, 235, and 236 in relation to the preparation, transmission, receipt, custody, and appreciation of the election returns, a pre-proclamation controversy, section 243 of the OEC it restrictively enumerates as follows the issues which can be raised in a pre-proclamation controversy. Illegal composition of proceedings of the Board of Canvassers. The canvassed election returns are incomplete, contain material defects, appear to be tampered with or falsified, or contain discrepancies in the same returns or in other authentic copies thereof as mentioned in sections 233, 234, 235, and 236 of this code. The election returns were prepared under duress. Election protest. In Loyola versus Court of Appeals, the court considered the filing of the certification one day after the filing of an election protest as substantial compliance with the requirement. A similar issue was raised in the case of De Leon versus Nepomuceno, wherein it appears that the judgment in the election protest provided that the costs and expenses of the contest will be paid by the protestee and the intervenor. Quo Warranto. Quo Warranto is the remedy to try the right. Quo Warranto. Quo Warranto is the remedy to try the right to an office or franchise and to oust the holder from its enjoyment, while Mandamus only lies to enforce clear legal duties not to try disputed cases. Disputed titles. Mandamus. Quo Warranto. In Quo Warranto proceedings, the person suing must show that he had clear right to the office or to use or exercise of the office alleged usurped or unlawfully held by the respondent. Where petitioner was duly nominated by authority of the President for the position of Department Chief of the Aquaculture Department of SIFDEC, with offices located in the Philippines, and was appointed thereto for a 2-year term by unanimous vote of the SIFDEC Council of Directors, while respondent did not have such nomination and appointment, it behooved the respondent not to take the law into his own hands and forcibly occupy the different offices of SIFDEC. At the time when petitioner was discharging his office's duties in Tokyo, Japan, attending the annual SIFDEC Council meeting there, it is time that the martial law regime's legacy of the office of force be discarded, and that there be a return to the office and the rule of law. Respondent's recourse, if he felt entitled to the office, was to exhaust his administrative remedies with the proper Philippine authorities, and if not satisfied therewith, to go to court to assert his alleged rights. Respondent's unilaterally taking over of the office and then going to the lower court one day after the filing in this court of petitioner's petition and securing therein a restraining order against petitioner cannot be sanctioned under the rule of law. Next topic is local governments. Local governments. Autonomous regions and their relation to the national government. There shall be created an autonomous region in mostly Mindanao and the Cordilleras, consisting of provinces, cities, municipalities, and geographical areas, sharing common and distinctive historical and cultural heritage, economic and social structures, and other relevant characteristics within the framework of this Constitution and the national sovereignty, as well as territorial integrity of the Republic of the Philippines. Public corporations. The territorial and political subdivisions of the Republic of the Philippines are the provinces, cities, municipalities, and barangays. There shall be autonomous regions in Muslim Mindanao, and the Cordilleras are hereinafter divided. Concept. Distinguished from governmental owned or controlled corporations. A local government unit may be created, divided, merged, abolished, or its boundaries substantially altered either by law enacted by Congress in the case of a province, city, municipality, or any other political subdivision, or by ordinance passed by the Sangguniang Panlalawigan or Sangguniang Pambansod concerned in the case of a barangay located within its territorial jurisdiction, subject to such limitations and requirements prescribed in this code. Quasi-corporations. In the case at bar, respondent State College is classified under the code as a chartered institution. Chartered institution refers to any agency organized or operating under a special charter and vested by law with functions related to specific constitutional policies or objectives. This term includes the state universities and colleges and the monetary authority of the state. Emphasis is ours, as opposed to a GOCC defined in the following segment. A government-owned or controlled corporation refers to any agency organized as a stock or non-stock corporation vested with functions relating to public needs, whether governmental or proprietary in nature and owned by the government directly or through its instrumentalities, either wholly or where applicable as in the case of stock corporations, to the extent of at least 51% of its capital stock, provided that government-owned or controlled corporations may be further categorized by the Department of Budget, the Civil Service Commission, and the Commission on Audit for purposes of the exercise and discharge of their respective powers, functions, and responsibilities with respect to such corporations. Municipal corporations. The distinction petitioners attempt to make between the taxes under sections 14 and 21 of Tax Ordinance number 7794 is spacious. The point revisits section 143 of the LGC, Local Government Code, the very source of the power of municipalities and cities to impose a local business tax, to which any local business tax imposed by petitioner City of Manila must conform. It is apparent from a perusal thereof that when a municipality or city has already imposed a business tax on manufacturers, etc., of liquors, distilled spirits, wines, and any other article of commerce pursuant to section 143A of the Local Government Code, said municipality or city may no longer subject the same manufacturers, etc., to a business tax under section 143H of the same code. Section 143H may be imposed only on businesses that are subject to excise tax, VAT, or percentage tax under the NIRC. 143H. Local Government Code. Undeniably, petitioner mayor is tasked to enforce all laws and ordinances relative to the governance of the municipality and to implement all approved programs, projects, services, and activities of the municipality, and to ensure that all taxes and other revenues of the municipality are collected. He is obligated to institute or cause to be instituted administrative or judicial proceedings for the recovery of funds and property. However, in the performance of his duties, petitioner mayor should act within the confines of the law and not resort to the commission of a felony. A public officer is proscribed from resorting to criminal acts in the enforcement of laws and ordinances. He must exercise his power and perform his duties in accordance with law with the strict observance of the rights of the people, and never whimsically, arbitrarily, and despotically. Elements. Local government is considered to have properly exercised its police powers only when the following requisites are met. First, the interests of the public generally, as distinguished from those of a particular class, require the interference of the state. And two, the means employed are reasonably necessary for the attainment of the object sought to be accomplished and not unduly oppressive. The first requirement refers to the Equal Protection Clause, and the second to the Due Process Clause of the Constitution. Respondent municipality failed to comply with the Due Process Clause when it passed Resolution number 50, while it maintained that the gasoline filling station of petitioner was less than 100 meters from the nearest public school and church. The records do not show that it even attempted to measure the distance, notwithstanding that such distance was crucial in determining whether there was an actual violation of Section 44. The different local offices that responding municipality tapped to conduct an investigation never conducted such measurement either. Nature and functions. Every local government unit created or recognized under this code is a body politic and a corporate endowed with powers to be exercised by it in conformity with law. As such, it shall exercise powers as a political subdivision of the national government and as a corporate entity representing the inhabitants of its territory. Requisites for creation, conversion, division, merger, or dissolution. As a general rule, the creation of a local government unit or its conversion from one level to another level shall be based on verifiable indicators of viability and projected capacity to provide services to it. Income. It must be sufficient based on acceptable standards to provide for all essential government facilities and services and special functions commensurate with the size of its population as expected of the local government. Unit concerned. Population. It shall be determined as the total number of inhabitants within the territorial jurisdiction of the local government unit concerned. Land area. It must be contiguous unless it comprises two or more islands or is separated by a local government unit independent of the others, properly identified by metes and bounds with technical descriptions and sufficient to provide for such basic services and facilities to meet the requirements of its populace. Compliance with the foregoing indicators shall be attested to by the Department of Finance, the National Statistics Office, and the Lands Management Bureau of the Department of Environment and Natural Resources. Principles of local autonomy. The Constitution has expressly adopted a policy of ensuring the autonomy of LGUs. To highlight its significance, the entire Article 10 of the Constitution was devoted to laying down the bedrock upon which this policy is anchored. It is also pursuant to the mandate of the Constitution enhancing local autonomy that the LGC or Local Government Code was enacted. Verily, local autonomy means a more responsive and accountable local government structure instituted through a system of decentralization. In Limbona versus Manjilin, the court elaborated on the concept of decentralization. Thus, autonomy is either decentralization of administration or decentralization of power. When there is decentralization of administration, when the central government delegates administrative powers to political subdivisions in order to broaden base. In the process to make and ensure the fullest. At the same time, it leaves the central government decentralization of administration. Decentralization of power. Involves an abdication, political abdication. Political power in the favor of local government units. Is declared to be autonomous. In that case, the autonomous government is free to chart its own destiny and shape its future with minimum intervention from central authorities. Abdication of political power in the favor of local government units declared to be autonomous. There is decentralization of administration in the central government delegates administrative powers to political subdivisions in order to broaden the base of government power and in the process to make local governments more responsive and accountable and ensure their fullest development as self-restrained communities and make them more effective partners in the pursuit of national development and social progress. At the same time, it relieves the central government of the burden of managing local affairs and enables it to concentrate on national concerns. Decentralization of power, on the other hand, involves an abdication of political power in the favor of local government units declared to be autonomous. In that case, the autonomous government is free to chart its own destiny and shape its future with minimum intervention from central authorities. Decentralization of power, decentralization of administration. Delegates abdicate. It is noteworthy that under the Charter, local autonomy is not instantly self-executing but subject to, among other things, the passage of a local government code, a local tax law, income distribution legislation, and a national representation law, and measures designed to realize autonomy at the local level. It is also noteworthy that in spite of autonomy, the Constitution places the local governments under the general supervision of the executive. It is noteworthy, finally, that the Charter allows Congress to include in the local government code provisions for removal of local officials, which suggests that Congress may exercise removal powers, and as the existing local government code has done, delegate its exercise to the President. Powers of local government units. Each local government unit shall have the power to create its own sources of revenues and to levy taxes, fees, and charges subject to such guidelines and limitations as the Congress may provide. As the Congress may provide consistent with the basic policy of local autonomy. Such taxes, fees, charges shall accrue exclusively to the local governments. Local government units shall have a just share as determined by law in the national taxes, which shall be automatically released to them. General Welfare Clause. The plenary power vested in the legislature to make statutes and ordinances to promote the health, morals, peace, education, good order or safety, and general welfare of the people. Eminent Domain. Eminent Domain is the right or power of a sovereign state to appropriate private property to particular uses to promote public welfare. It is an indispensable attribute of sovereignty, a power grounded in the primary duty of government to serve the common need and advance the general welfare. The power of eminent domain is inseparable in sovereignty, being essential to the existence of the state and inherent in government. Its exercise is prescribed by only two constitutional requirements. First, that there must be a just compensation, and second, that no person shall be deprived of life, liberty, or property without due process of law. A local government unit may, through its chief executive and acting pursuant to ordinance, exercise the power of eminent domain for public use or purpose or welfare for the benefit of the poor and the landless, upon payment of just compensation pursuant to the provisions of the Constitution and pertinent laws, provided, however, that the power of eminent domain may not be exercised unless a valid and definite offer has been Otro. A local government unit may, through its chief executive acting pursuant to an ordinance, exercise the power of eminent domain for public use or purpose or welfare for the benefit of the poor and the landless, upon payment of just compensation. Pursuant to the provisions of the Constitution and pertinent laws, provided, however, that the power of eminent domain may not be exercised unless a valid and definite offer has been previously made to the owner, and such offer was not accepted. Provided further that the local government unit may immediately take possession of the property upon the filing of the expropriation proceedings and upon making a deposit with the proper court of at least 15%. The fair market value. The fair market value of the property based on the current tax declaration of the property to be expropriated, provided finally that the amount to be paid for the expropriated property shall be determined by the proper court based on the fair market value of the time of the taking of the property. A local government unit may, through its chief executive and acting pursuant to an ordinance, exercise the power of eminent domain for public use or purpose or welfare for the benefit of the poor and the landless upon payment of just compensation, pursuant to the provisions of the Constitution and pertinent laws, provided, however, that the power of eminent domain may not be exercised unless a valid and definite offer has been previously made to the owner, and such offer was not accepted. Provided further that the local government unit may immediately take possession of the property upon the filing of the expropriation proceedings and upon making a deposit with the proper court of at least 15% of the fair market value. Otro. Taxing power. Section 142 of the Local Government Code grants municipalities the power to levy taxes, fees, and charges not otherwise levied by provinces. The Court of Tax Appeals, sitting as a division, has jurisdiction to review by appeal decisions, rulings, and resolutions of the Judicial Trial Court over local taxes, which includes real property taxes. Among the common limitations of the taxing power of local government units is Section 133 of the Local Government Code, which states that unless otherwise provided herein, the taxing power of LGUs shall not extend to taxes on the gross receipts of transportation of tractors and persons engaged in the transportation of passengers or freight by hire and common carriers by air, land, or water, except as provided in this code. Closure and opening of roads. A local government unit may pursuant to an ordinance permanently or temporarily close or open any local road park or square falling within its jurisdiction, provided however that in case of permanent closure, such ordinance must be approved by at least 2/3 of all the members of the Sanggunian, and when necessary and adequate substitute for the public facility that is subject to closure is provided. Legislative power. Under the Local Government Code, local legislative power within the city is to be exercised by the Sangguniang Panglungsod, which shall be comprised of elected district and sectoral representatives. The sectoral representatives, moreover, shall be limited to 3 members coming from enumerated identified sectors. Significantly, nothing in the law allows the creation of another local legislative body that will enact, approve, or reject local laws either through the regular legislative process or through initiative or referendum. Requisites for valid ordinance. A municipal ordinance is different from a resolution. An ordinance is a law, but a resolution is merely a declaration of the sentiment or opinion of a law-making body. A law-making body on a specific matter. Ordinance is a law. But a resolution is merely a declaration of the sentiment or opinion of a law-making body on a specific matter. An ordinance possesses a general and permanent character, but the resolution is temporal in nature. Additionally, the two are enacted differently. A third reading is necessary for an ordinance but not for a resolution, unless decided otherwise by a majority of all the Sangguniang members. Local initiative and referendum. In several cases, this court considered issues which were not raised by either party when these issues are necessary for the complete resolution of the cases. The court can review and assign errors which are necessary to arrive at a just resolution of the case. With all the more reason can it review a matter raised as a defense by a party to uphold the validity of a resolution as in the case. Section 124B of the LGC provides that initiatives shall extend only to subjects or matters which are within the legal powers of the Sanggunian to enact. Section 127 of the LGC gives the courts authority to declare null and void any proposition approved pursuant to this chapter for a violation of the Constitution or want of capacity of the Sanggunian concerned to enact the said measure. Significantly, the power of the courts to nullify propositions for being ultra vires extend only to those already approved, those which have been approved by a majority of the votes cast in the initiative election called for the purpose. In other words, the courts can review the terms only of an approved ordinance. It will be premature for the courts to review the proposition contained in an initiative petition that has yet to be voted for by the people, because at that point there is no actual controversy that the courts may adjudicate. This begs the question of which tribunal can review the sufficiency of an initiative petition. Ultra vires acts. Outside of the municipality's jurisdiction is considered as a void ultra vires act. While an act attended only by an irregularity but remains within the municipality's power is considered an ultra vires act subject to ratification and or validation. Outside. corporate powers. Every local government unit as a corporation shall have the following powers: to have continuous succession in its corporate name, to sue and be sued, to have and use a corporate seal, to acquire and convey real or personal property, to enter into contracts, and to exercise such other powers as are granted to corporations subject to the limitations provided in this code and other laws. Local government units may continue using, modify, or change their existing corporate seals, provided that newly established local government units or those without corporate seals may create their own corporate seals, which shall be registered with the Department of Interior Department of Interior and Local Government, provided further that any change of corporate seal shall also be registered as provided herein, unless otherwise provided in this code. Contract may be entered into by the local chief executive in behalf of the local government unit without prior authorization by the sangguniang concerned. A legible copy of such contract shall be posted at a conspicuous place in the provincial capital where the city, municipal, or barangay are. Local government units shall enjoy full autonomy in the exercise of their proprietary functions and in the management of their economic enterprises, subject to the limitations provided in this code and other applicable laws. Liability of local government units. Local government units and their officials are not exempt from liability for death or injury to persons or damage to property. Settlement of boundary disputes. Since the effectivity of Republic Act No. 6128, the Sangguniang Panlalawigan has been the primary tribunal responsible in the amicable settlement of boundary disputes between or among two or more municipalities located in the same province. With the LGC of 1991, however, a major change has been introduced that in the event that the Sangguniang fails to effect a settlement, it shall not only issue a certification to that effect but must also formally hear and decide the case within the reglementary period. Unlike Republic Act No. 6128 and BP 337, the LGC of 1991 grants an expanded role to the Sangguniang Panlalawigan concerned in resolving cases of municipal boundary disputes. Aside from having the function of bringing the contending parties together, intervening, or assisting in the amicable settlement of the case, the Sangguniang Panlalawigan is now specifically vested with original jurisdiction to actually hear and decide the dispute in accordance with the procedures laid down in the law and its implementing rules and regulations. This situation in effect reverts to the old rule under the RAC prior to its amendment by Republic Act No. 6128, under which the provincial boards were empowered to investigate, hear the parties, and eventually decide the case on the basis thereof. On the other hand, under the LGC of 1991, the trial court loses its power to try at the first instance cases of municipal boundary disputes only in the exercise of its appellate jurisdiction, but the proper RTC decide the case on appeal should any party aggrieved by the decision of the Sangguniang Panlalawigan elevate the same. Local officials. An elective local official must be a citizen of the Philippines, a registered voter in the barangay, municipality, city, or province, or in the case of a member of the Sangguniang Panlalawigan, Sangguniang Lungsod, or Sangguniang Bayan, the district where he intends to be elected. He a resident therein for at least 1 year immediately preceding the day of the election, and able to read and write Filipino or any other local language or dialect. Vacancies and succession. If a permanent vacancy occurs in the office of the governor or mayor, the vice mayor or vice mayor concerned, the vice governor or vice mayor concerned shall become the governor or mayor. If a permanent vacancy occurs in the offices of the governor, vice governor, mayor, or vice mayor, the highest ranking Sangguniang member, or in case of his permanent inability, the second highest ranking Sangguniang member shall become the governor, vice governor, mayor, or vice mayor, as the case may be. Subsequent vacancies in the said office shall be filled automatically by the other sangguniang members according to their ranking as defined herein. If a permanent vacancy occurs in the office of the punong barangay, the highest ranking sangguniang barangay member, or in the case of his permanent inability, the second highest ranking sangguniang member shall become the punong barangay. A tie between or among the highest ranking of sangguniang members shall be resolved by the drawing of lots. The successors, as defined herein, shall serve only the unexpired terms of their predecessors. For purposes of this chapter, a permanent vacancy arises when an elective local official fills a higher vacant office, refuses to assume office, fails to qualify, dies, is removed from office voluntarily, resigns, or is otherwise permanently incapacitated to discharge the functions of his office. For purposes of succession, as provided in this chapter, ranking in the sangguniang shall be determined on the basis of the proportion of votes obtained by each winning candidate to the total number of registered voters in each district in the immediately preceding local election. Discipline. It is the considered opinion of the court that notwithstanding the change in the constitutional language, the Charter did not intend to divest the legislature of its right or the President of our prerogatives as confirmed by existing legislation to provide administrative sanctions against local officials. It is our opinion that the omission of "as may be provided by law" signifies nothing more than to underscore local government's autonomy from Congress and to break Congress's control over local government's affairs. The Constitution did not, however, intend for the sake of local autonomy to deprive the legislature of all authority over municipal corporations, in particular concerning discipline. Elective officials, candidates for the position of governor, vice governor, or member of the Sangguniang Panlalawigan, or mayor, vice mayor, or member of the Sangguniang Panglunsod of highly urbanized cities must be at least 23 years of age on election day. Preventive suspension. The successive 60-day suspensions imposed on Mayor Rodolfo Ganzon is albeit another matter. What bothers the court, and what indeed looms very large, is the fact that since the mayor is facing 10 administrative charges, the mayor is in fact facing the possibility of 600 days of suspension. In the event that all 10 cases yield prima facie findings, the court is not, of course, tolerating misfeasance in public office, assuming that Mayor Ganzon is guilty of misfeasance. But it is certainly another question to make him serve 600 days of suspension, which is effectively to suspend him out of office. The plain truth is that this court has been ill at ease with suspensions because it is out of the ordinary to have a vacancy in local government. The sole objective of suspension is simply to prevent the accused from hampering the normal course of the investigation with his influence and authority over possible witnesses, or to keep him off the records and other evidence. It is a means and no more to assist prosecutors in firming up a case, if any, against an erring local official. Under the local government code, it can not exceed 60 days, which is to say that it need not be exactly 60 days long if a shorter period is otherwise sufficient, and which is also to say that it ought to be lifted if prosecutors have achieved the purpose in a short-term span. Removal. The Congress shall enact a local government code which shall provide for a more responsive and accountable local government structure instituted through a system of decentralization with effective mechanisms of recall, initiative, and referendum, allocate among the different local government units their powers, responsibilities, and resources, and provide for the qualifications, election, appointment, and removal terms, salaries, powers, and functions and duties of local officials, all other matters relating to the organization and operation of the local units. Administrative appeal. The thrust of the rule on exhaustion of administrative remedies is that courts must follow administrative agencies to carry out their functions and discharge their responsibilities within the specialized areas of their respective competence. Doctrine of condonation. The court, citing Civil Service Commission versus Soho, also clarified that the condonation doctrine would not apply to appointive officials since, as to them, there is no sovereign will to disenfranchise. The OSG is correct that the condonation doctrine has been abandoned by the court in Carpio Morales versus Court of Appeals. In the said case, the court declared the doctrine was unconstitutional, but stressed that its application should only be prospective. Thus, it should, however, be clarified that this court's abandonment of the condonation doctrine should be prospective in application for the reason that judicial decisions applying or interpreting the laws or the Constitution, until reversed, shall form part of the legal system of the Philippines. Unto this court devolves the sole authority to interpret what the Constitution means. All persons are bound to follow its interpretation, as explained in the Castro versus Judicial Bar Council. Judicial decisions assume the same authority as the statute itself, and until authoritatively abandoned, necessarily become, to the extent that they are applicable, criteria that must control the actuations not only of those called upon to abide by them, but also of those duty-bound to enforce obedience to them. Hence, while the future may untimely uncover a doctrine's error, it should be, as a general rule, recognized as a good law prior to its abandonment. The condonation doctrine does not apply to a criminal case. Appointive officials. The law provides for the preventive suspension of appointed local officials and employees pending investigation of the charges against them. The suspension given to private respondents cannot therefore be considered unjustified, for it is one of those sacrifices which holding a public office requires for the public good. To be entitled to back salaries, private respondents must not only be found innocent of the charges, but their suspension must likewise be unjustified. Recall: the Congress shall enact a local government code which shall provide for a more responsive and accountable local government structure. We continue. National economy and patrimony. Exploration, development, and utilization of natural resources. It's 3:54 p.m. May 16, 2022. All lands of the public domain, waters, minerals, coal, petroleum, and other mineral oils, all sources of potential energy, fisheries, forests, or timber, wildlife, flora, and fauna, and other natural resources are owned by the state. With the exception of agricultural lands, all other natural resources shall not be alienated. The exploration, development, and utilization of natural resources shall be under the full control and supervision of the state. The state may directly undertake such activities, or it may enter into co-production, joint venture, or production sharing agreements with Filipino citizens or corporations or associations, at least 60% of whose capital is owned by such citizens. Such agreements may be for a period not exceeding 25 years, renewable, or not more than 25 years, and under such terms and conditions as may be provided by law. In cases of water rights or irrigation, water supply, fisheries, or industrial uses other than development of waterproof beneficial use may be the measure and limit of the grant. Franchises, authorities, and certificates for public utilities. No franchise, certificate, or any other form of authorization for the operation of public utility shall be granted except to citizens of the Philippines or to corporations or associations organized under the laws of the Philippines, at least 60% of whose capital is owned by such citizens. Nor shall such franchise, certificate, or authorization be exclusive in character or for a longer period than 50 years. Neither shall any any such franchise or right be granted except under the condition that it shall be subject to amendment, alteration, or repeal by the Congress when the common good so requires. The state shall encourage equity, participation in public utilities by the general public, the participation of foreign investors in the governing body of any public utility enterprise shall be limited to their proportionate share in its capital, and all the executive and managing officers of such corporation or association must be citizens of the Philippines. Acquisition, ownership, and transfer of public and private lands. Lands of the public domain are classified into agricultural, forest, or timber, mineral lands, and national parks. Agricultural lands of the public domain may be further classified by law according to the uses to which they may be devoted. Alienable lands of the public domain shall be limited to agricultural lands. Private corporations or associations may not hold such alienable lands of the public domain except by lease for a period not exceeding 25 years, renewable for not more than 25 years, and not to exceed 1,000 hectares in area. Citizens of the Philippines may lease not more than 500 hectares or acquire not more than 12 hectares thereof by purchase, homestead, or grant. Practice of professions. Every citizen has a right Every citizen has a right to select a profession or course of study subject to fair, reasonable, and equitable admission and academic requirements. Organization and regulation of private and public corporations. The Constitution is quite emphatic that the operation of a public utility shall not be exclusive. Thus, no franchise, certificate, or any other form of authorization for the operation of a public utility shall be granted to citizens of the Philippines or to corporations organized under the laws of the Philippines, at least 60% of whose capital is owned by such citizens, nor shall such franchise, certificate, or authorization be exclusive in character or for a longer period than 50 years. Without doubt, the Corporation Code is the general law providing for the formation, organization, and regulation of private corporations. Monopolies, restraint of trade, and unfair competition. Private monopolies are not necessarily prohibited. The use of the word regulate in the Constitution indicates that some monopolies properly regulated are allowed. Regulate means include the power to control, to govern, and to restrain, but regulate should not be construed as synonymous with suppress or prohibit. To ensure fair competition and prevent cartels and monopolies in the downstream or oil industry, the following acts are hereby prohibited. Predatory pricing, which means selling or offering to sell any product at a price unreasonably below the industry average cost so as to attract customers to the detriment of competitors. A monopoly is a privilege or peculiar advantage vested in one or more persons or companies consisting in the exclusive right or power to carry on a particular business or trade, manufacture a particular article, or control the sale of a particular commodity. The 1987 Constitution strictly regulates monopolies, whether private or public, and even provides for the prohibition if public interest so requires. Social justice and human rights. Concept of social justice. Social justice is neither communism or despotism or atomism nor anarchy, but the humanization of laws and the equalization of social economic forces by the state. So that justice in its rational and objectively secular conception may at least be approximated. Social justice means the promotion of the welfare of all the people, the adoption by the government of means calculated to ensure economic stability at all the component elements of society through the maintenance of a proper economic and social equilibrium in the interrelations of the members of the community. constitutionally through the adoption of measures legally justifiable, or extra-constitutionally through the exercise of powers underlying the existence of all governments of time-honored principles of salus populi est supremo lex. Social justice, therefore, must be founded on the recognition of the necessity of interdependence among diverse and diverse, among diverse and diverse, among diverse, among diverse units of society and of the population, and of the protection that should be equally and evenly extended to all groups as a combined force in our social and economic life, consistent with the fundamental and paramount objective of the state of promoting the health, comfort, and quiet of all persons, and of bringing about the greatest good to the greatest number. The constitutional commitment to the policy of social justice cannot be understood to mean that every labor dispute shall automatically be decided in favor of labor. Economic, social, and cultural rights. The law, in protecting the rights of the laborer, authorizes neither oppression nor self-destruction of the employer. Although the Constitution is committed to the policy of social justice and the protection of the working class, it does not necessarily follow that every labor dispute will be automatically decided in favor of labor. The Agrarian Reform Program, being one of the immutable hallmarks of the 1987 Constitution, must be faithfully implemented to meet the ends of social justice. While the Constitution is committed to the policy of social justice and the protection of the working class, it should not be supposed that every labor dispute will be automatically decided in favor of labor. The general rule is that the just compensation to which the owner of the condemned property is entitled to the market value. Market value is that sum of money which a person, desirous but not compelled to buy, and an owner willing but not compelled to sell, would agree on as a price to be paid by the buyer and receiver by the seller. Commission on Human Rights. The Commission on Human Rights shall have the following powers and functions: investigate on its own or on complaint by any party all forms of human rights violations involving civil and political rights, adopt its operational guidelines and rules of procedure, and cite for contempt for violations thereof in accordance with the rules of court. Number 3. Provide appropriate legal measures for the protection of human rights of all persons within the Philippines as well as Filipinos residing abroad, and provide for preventive measures and legal aid services to the underprivileged whose human rights have been violated or need protection. 4th, exercise of visitorial powers over jails, prisons, or detention facilities. 5th, establish a continuing program of research, education, and information to enhance respect for the primacy of human rights. 6. Recommend to Congress effective measures to promote human rights and to provide for compensation to victims of violations of human rights or their families. 7. Monitor the Philippine government's compliance with international treaty obligations on human rights. 8. Grant immunity from prosecution to any person whose testimony or whose possession of documents or other evidence is necessary or convenient to determine the truth in any investigation conducted by it or under its authority. 9. Request the assistance of any department, bureau, office, or agency in the performance of its functions. 10. Appoint its officers and employees in accordance with law. And 11. Perform such other duties and functions as may be provided by law. Composition and qualification of members. The 1987 Constitution added the Ombudsman. 1987 added the Ombudsman and his deputies. And the members of the Commission on Human Rights. To those who must be natural born citizens. Since the position of chairman of the Commission on Human Rights is not among the positions mentioned in the first sentence of Section 16, Article 7 of the 1987 Constitution, appointments which are to be made with confirmation of the Commission on Appointments follows that the appointment by the President of the Chairman of the CHR is to be made without the review or participation of Commission appointments. To be more precise, the appointment of the Chairman and members of the Commission on Human Rights is not specifically provided for in the Constitution itself. Unlike the Chairman and members of the Civil Service Commission, the Commission on Elections, and the Commission on Audit, those appointments are expressly vested by the Constitution and the President with the consent of the Commission on Appointments. The President appoints the Chairman and members of the Commission on Human Rights pursuant to the second sentence in Section 16, Article 7, that is without the confirmation of the Commission on Appointments, because they are among the officers of government whom the President may be authorized by law to appoint. In Section 2C, Executive Order Number 163, 5th of May 1987 authorizes the President to appoint the Chairman and members of the Commission on Human Rights. It provides the Chairman and the members of the Commission on Human Rights shall be appointed by the President for a term of 7 years without reappointment. Appointment to any vacancy shall be only for the unexpired term of the predecessor. Education, Science, Technology, Arts, Culture, and Sports. Section 15, Article 14 of the Constitution, which deals with the subject of arts and culture, provides that the state shall conserve, promote, and popularize the nation's historical and cultural heritage and resources. Since this provision is not self-executory, Congress passed laws dealing with the preservation and conservation of our cultural heritage. One such law is Republic Act No. 166, or the National Cultural Heritage Act of 2009, which empowers the National Commission for Culture and the Arts and other cultural agencies to issue a cease and desist order when the physical integrity of the national cultural treasures or important cultural properties is found to be in danger of destruction or significant alteration from its original state. This law declares 166. This law declares that the state should protect the physical integrity of the heritage property or building if there is danger of destruction or significant alteration from its original state. Physical integrity refers to the structure itself, how strong and sound the structure is. The same law does not mention that another project, building or property, not itself a heritage property or building, may be the subject of a cease and desist order when it adversely affects the background view, vista, or sightline of a heritage, a property or building. Thus, Republic Act No. 10066 cannot apply to the Torre de Manila condominium project. In the present case, nowhere is it found in Ordinance No. 8119 or in any law, ordinance or rule for that matter, that the construction of a building outside the Rizal Park is prohibited if the building is within the background, sightline, or view of the Rizal Monument. Thus, there is no legal duty on the part of the City of Manila to consider, in the words of the dissenting opinion, the standards set under Ordinance No. 8119. Application to MCI, PDI for the Torre de Manila. Since under the boundaries of Rizal Park, while the Rizal Park was being declared a National Historical Site, the area where Torre de Manila is being built is a privately owned property that is not part of the Rizal Park that has been declared as a National Heritage Site in 1995, and the Torre de Manila area is in fact well beyond the Rizal Park, according to NHCP Chairperson Dr. Maria Serena Diokno. Neither has the area of the Torre de Manila been designated as a heritage zone, a cultural property, a historical landmark, or even a national treasure. The Venice Charter is merely a codification of guiding principles for the preservation and restoration of ancient monuments, sites, and buildings. It brings together principles in the field of historical conservation and restoration that have been developed, agreed upon, and laid down by experts over the years. Each country, however, remains responsible for applying the plan within the framework of its own culture and traditions. The Venice Charter is not a treaty and therefore does not become enforceable as law. The Philippines is not legally bound to follow its directive, as in fact these are not directives but mere guidelines, a set of the best practices and techniques that have been proven over the years to be most effective in preserving and restoring historical monument sites and buildings. The development and promotion of culture and the arts are recognized as a vital aspect of nation building. During the period of Freedom Constitution, then President Corazon Aquino recognized the importance of promoting culture and the arts in the development of our national identity. Last President Aquino issued Executive Order Number 118, which created the Presidential Commission on Culture and Arts. In 1992, Congress enacted Republic Act Number 7356, which established the National Commission for Culture and the Arts and replaced the Presidential Commission on Culture and Arts. One of the mandates of the National Commission for Culture and the Arts is to extend financial and economic assistance such as subsidies, artist funds, and social security to promote cultural development and protect artists and cultural workers. Academic freedom. This is especially true in the case of institutions of higher education, which consistent with academic freedom and constitutional autonomy has the prerogative to provide standards for its academic personnel and determine whether the same have been met. The Supreme Court has ruled that the school-student relationship is contractual in nature. Such contract is imbued with public interest because of the high priority given by the Constitution to education and the grant to the state supervisory and regulatory powers over all educational institutions. The school undertakes to provide students with education sufficient to enable them to pursue higher education or a profession. On the other hand, the students agree to abide by the academic requirements of the school and to observe its rules and regulations. An educational institution has the power to adopt and enforce such rules as may be deemed expedient for its government, this being incident to the very object of incorporation and indispensable to the successful management of the college. The school's power to instill discipline in their students is subsumed in their academic freedom, and that the establishment of rules governing university student relations, particularly those pertaining to student discipline, may be regarded as vital, not merely to the smooth and efficient operation of the institution, but to its very survival. The power of the school to impose disciplinary measures extends even after graduation for any act done by the student prior thereto. Every citizen has a right to select profession or course of study subject to fair, reasonable, and equitable admission and academic requirements. As the primary training and educational institution of the Armed Forces of the Philippines, it certainly has the right to invoke academic freedom and the enforcement of its internal rules and regulations, which are the honor code and the honor system in particular. That ends the political law. Now we are in public international law. Let's have a short break. Public international law. Public international law concepts. The international law of the sea is generally defined as a body of treaties, rules, and customary norms governing the uses of the sea, the exploitation of its resources, and the exercise of jurisdiction over maritime regimes. It is a branch of public international law regulating the relations of states with respect to the uses of the oceans. The UNCLOS is a multilateral treaty which was opened for signature on December 10, 1982 at Montego Bay, Jamaica. It was ratified by the Philippines in 1984 but came into force on November 16, 1984 upon the submission of the 60th ratification. Relationship between international law and Philippine domestic law. A state that has contracted valid international obligations is bound to make in its legislation those modifications that may be necessary to ensure the fulfillment of the obligations undertaken. Under the 1987 Constitution, international law can become part of the sphere of domestic law either by transformation or incorporation. The transformation method requires that an international law be transformed into domestic law through a constitutional mechanism such as local legislation. The incorporation method applies when by mere constitutional declaration international law is deemed to have the force of domestic law. Treaties become part of the law of the land through a transformation pursuant to Article 7, Section 21 of the Constitution, which provides that no treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate. Thus, treaties or conventional international law must go through a process prescribed by the Constitution for it to be transformed into municipal law that can be applied to domestic conflicts. Sources of international law. Generally, the parties to an international agreement are given the freedom to choose the form of their agreement. International agreements may be in form of first, treaties which require legislative concurrence after executive ratification, or second, executive agreements which are similar to treaties except that they do not require legislative concurrence and are usually less formal and deal with a narrower range of subject matters than treaties. Under Article 2 of the Vienna Convention on the Law of Treaties, a treaty is defined as an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments and whatever its particular designation. Article 38, the International Court of Justice Statute, the most authoritative enumeration of the sources of international law. Article 38 of the Statute of the International Court of Justice does not specifically include generally accepted principles of international law. To be sure, it is not quite the same as the general principles of law recognized under Article 38. Renowned publicist Ian Brownlee suggested, however, that general principles of international law may refer to rules of customary laws, to general principles of law as in Article 38, or to logical propositions resulting from judicial reasoning on the basis of existing international law and municipal analogies. Indeed, judicial reasoning has been the bedrock of Philippine jurisprudence on the determination of generally accepted principles of international law and consequent application of the incorporation clause. The most widely accepted statement of sources of international today is Article 38, Paragraph 1 of the Statute of the International Court of Justice, which provides that the court shall apply international custom as evidence of a general practice accepted as law. In Vires versus Canada, the court held thus general accepted principles of international law by virtue of the incorporation clause of the Constitution form part of the laws of the land, even if they do not derive from treaty obligations. The classical formulation in international law sees those customary rules accepted as binding result from the combination of two elements: established, widespread, and consistent practice on the part of states, and the psychological element known as the Opinion juris sive necessitatis, opinion as to law or necessity. Implicit in the latter element is a belief that the practice in question is rendering obligatory by the existence of the rule of law requiring it. Generally accepted principles of international law refers to norms of general or customary international law which are binding on all states. Renunciation of war as an instrument of national policy, the principle of sovereign immunity, persons' right to life, liberty, and due process, and pacta sunt servanda, among others. The concept of generally accepted principles of law has also been depicted in this wise. Some legal scholars and judges look upon certain general principles of law as a primary source of international law because they have the character of jus rationale and are valid through all kinds of human societies. O'Connell holds that certain principles are part of international law because they are basic to legal systems generally and hence part of the jus gentium. These principles, he believes, are established by a process of reasoning based on the common identity of all legal systems. If there should be doubt or disagreement, one must look to state practice and determine whether the municipal law principle provides a just and acceptable solution. Effect of United Nations Declaration Security Council resolutions. While a treaty ratified by the President is binding upon the Philippines in the international plane, it would need the concurrence of the legislature before it can be considered as valid and effective in the Philippine domestic jurisdiction. Treaties which have the impact of statutory law in the Philippines can amend or prevail over prior statutory enactments. Executive agreements which are at the level of implementing rules and regulations or administrative orders in the domestic sphere have no such effect of actions of organs of international law, international organizations created by treaty. Generally, the parties to an international agreement are given the freedom to choose the form of government of their agreement. International agreements may be in the form of treaties which require legislative concurrence and after executive treaties. Executive agreements which are similar to treaties. Executive agreements so it's equal to accept that they do not require legislative concurrence. Usually less formal and deal with narrower matters than treaties. Under Article 2 of the Vienna Convention on the Law on Treaties, a treaty is defined as an international agreement. It is an international agreement included in written form and governed by international, whether embodied in a single instrument or in two or more related instruments, whatever its particular designation. Written form and governed. Subjects of international law, perhaps the earliest understanding of citizenship was given by Aristotle, who sometime in 384 to 322 BC described the citizen to refer to a man who shared in the administration of justice and the holding of an office. Aristotle saw its significance if only to determine the constituency of the state, which he described as being composed of such persons who would be adequate in number to achieve a self-sufficient existence. The concept grew to include one who would both govern and be governed, for which qualifications like autonomy, judgment, and loyalty could be expected. Citizenship was seen to deal with rights and entitlements on the one hand and with concomitant obligations on the other. In its ideal setting, a citizen was active in public life and fundamentally willing to submit his private interests to the general interest of society. Subjects. states. The common thread, the UDHR, UNCRC, and ICCPR is to obligate the Philippines to grant nationality from birth and ensure that no child is stateless. This grant of nationality must be at the time of birth, and it cannot be accomplished by the application of our present naturalization laws, Commonwealth Act number 473 as amended, and Republic Act number 9139, both of which require the applicant to be at least 18 years old. The principles found in two conventions, while yet unratified by the Philippines, are generally accepted principles of international law. The first is Article 14 of the 1930 Hague Convention on certain questions relating to the conflict of nationality laws, under which a foundling is presumed to have the nationality of the country of birth. To wit, Article 14, a child whose parents are born unknown shall have the nationality of the country of birth. If the child's parentage is established, its nationality shall be determined by the rules applicable in cases where the parentage is known. A foundling is, until the contrary is proved, presumed to have been born on the territory of the state. Territory of the state in which it was found. The second is the principle that a foundling is presumed born of citizens of the country where it is found, contained in Article 2 of the 1961 United Nations Convention on the Reduction of Statelessness. Article 2. A foundling found in the territory of a contracting state shall, in the absence of proof to the contrary, be considered to have been born within the territory of parents possessing the nationality of that state. International organizations. International organizations. Thus, Section 2 of the General Convention on the Privileges and Immunities of the United Nations states that the UN shall enjoy immunity from every form of legal process, except insofar as in any particular case it has expressly waived its immunity. Section 4 of the Convention on the Privileges and Immunities of the Specialized Agencies likewise provides that the specialized agencies shall enjoy immunity from every form of legal process, subject to the same exception. Finally, Article 50, Part 1 of the IDB Charter and Section 5 of the Headquarters Agreement similarly provide that the bank shall enjoy immunity from every form of legal process except in cases arising out of or in connection with the exercise of its powers to borrow money, to guarantee obligations, or to buy and sell or underwrite the sale of securities. Individuals. The common thread of the UDHR, UNCRC, and ICCPR is to obligate the Philippines to grant nationality from birth and ensure that no child is stateless. This grant of nationality must be at the time of birth, and it cannot be accomplished by the application of our present naturalization laws, Commonwealth Act number 473 as amended, and Republic Act number 9139, both of which require the applicant to be at least 18 years old. The principles found in two conventions, while yet unratified by the Philippines, are generally accepted principles of international law. The first is Article 14 of the 1930 Hague Convention on certain questions relating to the conflict of nationality laws, under which a foundling is presumed to have the nationality of the country of birth. To wit, Article 14, a child whose parents are born unknown shall have the nationality of the country of birth. If the child's parentage is established, its nationality shall be determined by the rules applicable in cases where the parentage is known. A foundling is, until the contrary is proved, presumed to have been born on the territory of the state in which it was found. Presumed to have been born on the territory of the state. Presumed to have been born on the territory of the state in which it was found. Foundling. The second is the principle that a founding presumed of citizens of the country where he is found contained in Article 2. A founding found in the territory of a contracting state shall, in the absence of proof to the contrary, be considered to have been born within the territory of parents possessing the nationality of the state. Others, petitioners' evidence shows that at least 60 countries in Asia, North and South America, and Europe have passed legislation recognizing foundlings as its citizen. 42 of those countries follow the jus sanguinis regime. Of the 60, only 33 are parties to the 1961 Convention on Statelessness. 26 are not signatories to the convention. Also, the Chief Justice at the February 2, 2016 oral arguments pointed out that in 166 out of 189 countries surveyed, foundlings are recognized as citizens. These circumstances, including the practice of jus sanguinis countries, show that it is generally accepted principle of international law to presume foundlings as having been born of nationals of the country in which the foundling is found. Jurisdiction of states. Diction, basis, territoriality principle. Basis of jurisdiction. Finally, the 1987 Philippine Constitution, the current fundamental law in place that provided inter alia all other territories under which the Philippines has sovereignty or jurisdiction, is a modification of the phrase in the 1973 Constitution, which stated all other territories belonging to the Philippines by historic right or legal title. It was explained that the word has is of a broader scope than exercise, so that it clearly allows juridical retention of a territory even when it is physically wrested by stronger force. The phrase was explained to import a durative sense, that is, it included any territory over which the Philippines has sovereignty or jurisdiction, even if such territory over which the Philippines might establish sovereignty or jurisdiction in the future. It clearly, therefore, did not abandon any claim to Sabah or to any other territory, but left all such matters to determination through international processes. Territoriality principle view that the Philippine national territory refers to areas over which the Philippines has sovereignty or jurisdiction. The 1987 Constitution defines the national territory to include not only islands or rocks above water at high tide, but also the seabed, some soil, and other submarine areas over which the Philippines has sovereignty or jurisdiction. Article 1 of the 1987 Constitution provides, the national territory comprises the Philippine archipelago, all the islands and waters embraced therein, and all other territories over which the Philippines has sovereignty or jurisdiction, including its consisting of its terrestrial, fluvial, and aerial domains, including its territorial sea, the seabed, the subsoil, the insular zones, and other submarine areas. The waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. Thus, The Philippine national territory refers to areas over which the Philippines has sovereignty or jurisdiction. The Constitution mandates the state shall protect the nation's marine wealth in its archipelagic waters, territorial sea, and exclusive economic zone, and preserve its use and enjoyment exclusively to Filipino citizens. Nationality, principle, and statelessness. The common thread of the UDHR, UNCRC, and ICCPR is to obligate the Philippines to grant nationality from birth and ensure that no child is stateless. This grant of nationality must be at the time of birth and cannot be accomplished by the application of our present naturalization laws. Commonwealth Act No. 473 as amended, Public Act No. 9139. Both of which require the applicant to be at least 18 years old. The principles found in two conventions, while yet unratified by the Philippines, are generally accepted principles of international law. The first is Article 14 of the 1938 Convention on Certain Questions relating to the conflict of nationality laws, under which a founding is presumed to have the nationality of the country at birth. To wit, Article 14, a child whose parents are both unknown shall have the nationality of the country of birth. If the child's parentage established, its nationality shall be determined by the rules applicable in cases where the parentage is known. A foundling is, until the contrary is proved, presumed to have been born on the territory of the state in which it was found. The second is the principle that a foundling is presumed born of citizens of the country where he is found, contained in Article 2 of the 1961 United Nations Convention on the Reduction of Statelessness. Article 2. A foundling found in the territory of a contracting state shall, in the absence of proof to the contrary, be considered to have been born within the territory of parents possessing the nationality of that state. Petitioner's evidence shows that at least 60 countries in Asia, North and South America, and Europe have passed legislation recognizing foundlings as its citizen. 42 of those countries follow the jus sanguinis regime. Of the 60, only 33 are parties to the 1961 Convention on Statelessness, 26 are not signatories, etc. etc. Protective principle. The invocation of the doctrine of immunity from suit of a foreign state without its consent is appropriate, more specifically, insofar as alien armed forces is concerned. The starting point in Rakiza versus Bradford decision, 1945 decision, the solidity of the stand of petitioner is therefore evident. What was sought by private respondent and what was granted by respondent judge amounted to an interference with the performance of the duties of petitioner in the base area in accordance with the powers possessed by him under the Philippine-American Military Bases Agreement. This point was made clear in these words, assuming for purposes of argument that the military government, through the Bureau of Forestry, possesses the authority to issue a timber license to cut logs inside a military base. The basis agreement subjects the exercise of rights under a timber license issued by the Philippine government to the exercise by the United States of its rights, powers, and authority of control within the bases, and the findings of the Mutual Defense Board, an agency of both the Philippine and the United States governments, that continued logging operation by Mr. Henner within the boundaries of the U.S. naval base would not be consistent with the security and operations of the base is conclusive upon the respondent judge. The doctrine of a state immunity is not limited to cases which would result in a pecuniary charge against the sovereign or would require the doing of an affirmative act by prevention of the sovereign from doing an affirmative act pertaining directly and immediately to the most important public function of any government. The defense of the state is equally untenable as requiring it to do an affirmative act. That such an appraisal is not opposed to the interpretation of the relevant treaty provision by our government is made clear in the aforesaid manifestation and memorandum as amicus curiae, wherein joint petitioner for the grant of the remedy prayed for. Universality principle. Furthermore, if we consider the doctrine of sovereign immunity as a binding general principle of international law rather than an international customary norm, the particular rules and guidelines in its application and invocation may be determined on a domestic level, either through statute or by jurisprudence. Passive personality principle. According to Mr. Justice Holmes, a sovereign is exempt from suit without its own permission, not because of any formal conception or absolute theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. Exemptions from jurisdiction. By their voluntary act, nations may surrender some aspects of their state power in exchange for greater benefits granted by or derived from convention or pact. Act of State Doctrine. Act of State Doctrine is one of the methods by which states prevent their national courts from deciding disputes which relate to the internal affairs of another state, the other two being immunity and non-justiciability. It is an avoidance technique that is directly related to a state's obligation to respect the independence and equality of other states by not requiring them to submit to adjudication in a national court or to settlement of their disputes without their consent. It requires the foreign court to exercise restraint in the adjudication of disputes relating to legislative or other governmental acts which a foreign state has performed within its territorial limits. International organizations and their offices. Moving on, Holy See versus Rosario Jr. involved an action for annulment of sale of land against the Holy See as represented by the Papal Nuncio. The court upheld the petitioner's defense of sovereign immunity. It ruled that where a diplomatic envoy is granted immunity from the civil and administrative jurisdiction of the receiving state over any real action relating to private immovable property situated in the territory of the receiving state, which the envoy holds on behalf of the sending state for the purposes of their mission. With all the more reason should immunity be recognized as regards the sovereign state, which in that case is the Holy See. Thereafter, in Lascaux versus United Nations, the United Nations Revolving Fund for Natural Resources Exploration was sued before the NLRC for illegal dismissal. The court again upheld the doctrine of diplomatic immunity invoked by the fund. Finally, DFA versus NLRC involved an illegal dismissal case filed against the Asian Development Bank pursuant to its chapter and the Headquarters Agreement. The diplomatic immunity of the Asian Development Bank was recognized by the court. It bears to stress, according to Justice Puno, that all of these cases pertain to the diplomatic immunity enjoined by international organizations. Petitioner asserts that he is entitled to the same diplomatic immunity and he cannot be prosecuted for acts allegedly done in the exercise of his official functions. The term international organizations is generally used to describe an organization set up by agreement between two or more states under contemporary international law. Such organizations are endowed with some degree of international legal personality such that they are capable of exercising specific rights, duties, and powers. They are organized mainly as a means for conducting general international business in which the member state have an interest.
That's all, folks. Next video ba